nation, which sort of spread throughout the world, in large part through the kind of communication that is now possible as a result of globalization. Part of that globalization, of course, is the development of international human rights over the past 50 years, in the same sense that we've had the development of supranational international standards to deal with economic matters. We've had development of supranational and international standards to deal with human rights. Much like in the New Deal, post-New Deal period, we had development of federal role on economic regulation and the development of the federal role through incorporation on individual rights. And that international human rights development, I think, recognizes fundamentally that democracy has limits. Democracy is great for certain things, but it's not very good at other things. And it's particularly not good at protecting individual rights of the most vulnerable, and particularly not good at protecting the rights of, quote unquote, the enemy alien. And at the same time, international human rights, I think, calls into question the very notion of distinguishing between citizen and alien, citizen and foreign national, right? Because international human rights are predicated on a notion of human dignity, and human dignity doesn't turn on whether you have an American passport. So that development, I think, is critical in sort of understanding why the court reached the result it did. And then I think you see the confluence of both of these as sort of international, the globalization of the shrinking world and the development of international human rights, leading to a new judicial confidence in playing the role that is sort of typified by habeas corpus, but is more broadly the role of protecting individual rights from political processes. The Supreme Court, you might say the Supreme Court in these, 4 for 4, it's ruled against the president in the war on terror. That's remarkable, but it's not alone. Courts of last resort in many countries of the world have, in recent years, stood up to actions of the executive and the legislature working together on matters of national security in times of crisis to say, no, you've gone beyond principles of international human rights. And so the law lords, England's Supreme Court, struck down indefinite detention of suspected terrorist foreign nationals as a violation of the European Convention because it treated foreign nationals differently from British nationals. The law lords also struck down the use of torture evidence, even where the evidence is obtained by torture by other countries and not being used in a criminal setting. It said torture evidence can never be used. Again, adverting to international human rights standards. It struck down the use of secret evidence to impose control orders on suspected terrorists. The Canadian Supreme Court struck down the use of secret evidence against suspected foreign national terrorists, and just last month decided a remarkable decision in the Omar Khadr case where it basically held that the Canadian officials had an obligation to Khadr and his family because of the illegality that it saw the Supreme Court of our country recognizing at Guantanamo. The European Court of Human Rights has put human rights limits on interrogation, on what President Bush would call enhanced interrogation tactics, what the rest of the world knows as torture, and have also put limits on and forbade any deportation to a place where someone faces cruel, inhuman, or degrading treatment. Israel's Supreme Court have also put limits on the use of coercive interrogation tactics and have even sought to regulate targeted killings by the military in the course of their conflict in the occupied territories. And the German Constitutional Court in the last 2 years has twice struck down efforts of the legislature to put in place data mining laws to help find terrorists. Given the history of judicial deference in times of crisis, this is a remarkable trend, and it's an international trend. It's not the action of judicial activists in the U.S. It is a much broader trend, and I think what it reflects is this increasing recognition that, we used to think the real struggle was democracy versus totalitarian versus fascism versus communism. But we've now come to see that as democracy has prevailed, democracy has its limits. And precisely because democracy has its limits, courts have their role. And precisely because they are unelected, they exercise that role in a critical way as we go forward. Thank you very much.
Good afternoon. It is a real privilege to be addressing this audience. Let me start with just a quick thanks to Betsy and to Nancy for putting together such a terrific program. I want to make sure that we have plenty of time for comments and questions, so I'm going to try to keep my comments a little briefer than I'd intended. We're going to switch gears and speak about the Medellin case. Before I start, because of the active nature of the litigation and because of my role in that litigation, I do need to preface my remarks with the comment that the views that I'm about to express are my own, and they should not be attributed to either Mr. Medellin or the government of Mexico. So here we go. I think, given this audience, I can dispense with much of the background of the Medellin case, which didn't have the high profile of Boumediene, but certainly has, I think this audience in particular appreciates, a lot of implications for the status of international law in the United States courts. The Avena case, in which the United States fully participated, in the Avena case, the ICJ decided that the United States had violated, in the cases of 51 Mexican nationals, the obligations under the Vienna Convention on Consular Relations to provide consular notification and access. And as a result of those violations, the ICJ ordered the remedial obligation of review and reconsideration of the convictions and sentences of each of those 51 Mexican nationals. By Article 94.1 of the UN Charter, the United States undertook to comply with a judgment of the ICJ in any case to which is a party, and by virtue of the ICJ statute, that judgment is binding on the parties. Mr. Medellin, as one of the Mexican nationals who is directly subject to the Avena judgment, attempted to enforce his right to that remedial obligation in Texas courts. And as a result of that line of litigation, we were in the Supreme Court twice and tangentially once in a case by the name of Sanchez-Llamas. For purposes of my comments, I'm going to focus on the most recent Medellin case that was issued this term. In a 6-3 majority, the Supreme Court, in a decision penned by Justice Roberts, held that the obligation to comply with the Avena judgment did not yet have the status of domestic law, that an additional step was necessary, and so neither the court, the Supreme Court, nor the President, acting alone, had the ability to give it effect, the ability to comply. And for those prone to counting noses on the Supreme Court, I will note that every single justice of the Supreme Court, even Texas, acknowledged that the United States has an undisputed, unequivocal international law obligation to comply. The question is how to give that effect domestically. But it was undisputed throughout the course of this litigation that there's this international obligation to comply. It was determined by the President of the United States that it's in the paramount interest of the U.S. to comply. It's an interest that actually covers U.S. citizens traveling and working abroad, that protects our citizens because our own consular rights are protected. And hence, the President determined it was in the paramount interest. And yet here we are. Somehow, we have a Constitution in which neither the President nor the Supreme Court can give effect to a undisputed treaty obligation to bring the U.S. into compliance with international law. And instead, as the Supreme Court reasoned in its majority decision, we're left with two means that include either the voluntary compliance as a matter of grace by the states, or an English parliamentary type system where every decision must first be acted on by Congress before it can be domestically enforced. And I submit that both of those contingencies were specifically situations that the Constitution was designed to prevent. So I want to talk about, in the first part of my remarks, how we got here, and to highlight some of what I would consider extraordinary points of reasoning in the majority decision. You'll soon discover by extraordinary I mean